Welcome back to the Multifamily Investing Podcast. This is Charles Dobbins, the founder of the Multifamily Investing Academy and the multifamilyattorney.com. And every week we delve into the good, the bad, the ugly, the comic, the heartbreaking stories of multifamily ownership. They will inspire you to do what you've always dreamt of doing. So sit back and enjoy the best training on multifamily investing on the internet today. Enjoy.
Yeah, that's a great question.
Yeah, that's a great question.
It's a great question.
Great question.
It's a good question.
This is a really good question right here.
It's a great question, by the way.
That's a great question.
That's a really good question.
Yeah, so that's a great question, Charlie.
Great question.
Yeah, that's a great question.
You know, that's a great question.
Good question.
Great question.
Great question.
Yeah, I get that a lot.
Hey, everybody. Welcome back to this week's edition of the Multifamily Investing Academy podcast. I'm your host, Charles Dobbins, the multifamilyattorney.com. And today I have with me attorney Jeff Lerman, a guy almost as smart as I am. I mean, he obviously chose the right attire to wear today, where it's
I got the memo.
We like to show off our tans. And let me tell you something. I am glad I got Jeff here because he's an expert, especially in this concept of joint venture partnerships, which I tell you, if you can keep me away from the SEC, I'll take that path all day long and twice on Sundays. And so this joint venture concept is great. I want everybody to understand it. Jeff and I are going to dig down deep into it right now, but there's a real reason why I got Jeff on here, because you know how lawyers talk amongst each other. You know, we swap stories, we help each other out in our practices. I need Jeff to help me out in something that I saw the other day, and I want him to tell me if this is kosher or not as it relates to joint venture partnerships. Because my fear, and Jeff is going to correct me here, is my fear is that there are a lot of people out there working the joint venture angle in an attempt to avoid securities laws, when if it looks like a duck and it quacks like a duck and it walks like a duck, it's a duck, and don't try to call it something else, because the SEC will get you every time. So Jeff, are you ready?
Yeah, and Charlie, you know, put the intent aside. A lot of people do that innocently, inadvertently. They don't realize they're violating securities laws. But go ahead. I appreciate the tee up.
Okay. Yes. Okay. So
I can't charge you for this consultation. Is that what that?
That's exactly what this means. What do you think? I'm a fool? Come on. All right. So here's the situation. Let's take it the easy, or the way that most of the world is working. They're talking syndications. They're talking, and I know there's something else I got to talk to you about that's driving me crazy as well. They're talking about member-owned LLCs, and a portion of that ownership is sold off in the form of a membership interest in order to raise money to buy the multifamily property. And really, that's all I'm here to talk about is multifamily. So and when you do that, you are selling a security. The membership interest is a security as defined by the SEC. And so therefore you have to follow their rules and regulations, right?
Yeah, unless so let's say you and I are already in a deal, right? And let's say it's a joint venture. And let's say that that you have a buddy who you think would be a good add to the joint venture for whatever the reason happens to be. And so that person comes in and gets his piece, gets a membership interest or a piece of yours or mine or whatever, and now we're 3 instead of 2. Is that the scenario that you're describing, or what?
See, because you're getting into the joint ventureship yet. We're not even there yet. I want everybody to understand what they're typically taught. They're typically taught raise money, syndication. Somebody's a sponsor, somebody's the general partner, which I hate that term. Somebody is the one who puts the whole deal together, and they bring in the other members. So
right.
That's how you and I were essentially raised in this business. That's, and we see, and, God love her, one of my best friends, she is a great syndication attorney, a securities attorney, but there are other ways. There are other ways besides just the securitizing and the syndication side. So let me talk about the one thing before we get into the joint venture. Let me talk about one thing that drives me crazy. So you have what everyone is calling mistakenly the GP and the LP. And it's an LLC. So there are no partners. It's all members.
Exactly.
But one person or a group is touting themselves as a GP. And you're going to understand why I'm laying down this foundation, because this is going to help in the joint venture discussion. So there's one group that is calling themselves a GP. And they're the ones who are in charge. If you look to see the way that the deal is structured, that membership class provides them with all the control. And then there are the LPs, and these people are limited in their risk, or not really though. I mean, they're limited in their control, but it's not a limited partnership. They're still members just like everyone else. And so what I see all of these new investors thinking, and I don't know who started this, is that they're teaching people, oh, in order to be a sponsor, in order to be a GP, you've got to start out as an LP. And then you start building a resume. Yeah, you're shaking your head. No, so am I. You're building a resume. And then when you're ready, then you can come on over. Then you can come on over and you can get on the GP side. And we'll bring you into our GP side. You'll have to put some money into the deal, but you'll be a GP just like us. And then you can go out and be your own sponsor someday. True?
Makes no sense to me.
Thank you. It makes no sense to me whatsoever. I was never an LP in any deal. When I started buying property, I put the deals together and I was the sponsor. And that's how I went about doing it. I see these people doing it. They're all telling me like, oh no, I have to, in order for me to qualify as for a mortgage with a government sponsored entity, I need to show them that I've been a GP in other deals. No, you don't.
Yeah, no, I haven't heard anything like that.
Yeah. Okay. Now watch how this is going to be carved right into the joint venture discussion.
Okay.
So I say to them, okay, well, they want you to be a GP in their deal. Well, what are you going to do? What are your roles? What are your responsibilities? What are your duties? And then they showed me the operating agreement that carved these people into a separate class within the GP where they didn't have any control. But I'll tell you something, if that deal went south and those limited partners, somebody absconded, fraud, waste, and abuse, and they took off with the money, all the GPs are going to get sued equally. And this person who thought they were needed to have their name on a resume is going to lose their shirt. Because
and is the entity actually set up as a limited partnership, or is it set up as an LLC? But they're just calling themselves GP and LP.
Which kills me, absolutely kills
me.
I
would,
I hate that. That drives me crazy.
I mean, from that fact alone, I would just be really reluctant to do business with people like that, only because I would lose confidence in their ability to set up the entity and to structure the deal. It just doesn't make any sense.
Oh, one of the things I teach my students is you've got to get the nomenclature right. You've got to get the terminology correct, or you're going to look like some hick from Muskogee when you're talking to investors about my limited liability company and all my partners in the. It's like no, that's wrong. That's wrong. Don't say that. So all right. So now along comes Jeff Lerman, and he's got a new idea. He's got the newest, shiniest thing on the road, and I want you to go deep down, as deep as you want to, into joint venture partnerships, and then I'm going to show you an organizational chart. And I think I can't wait to see your eyes bug out when you see it. But let's see. Go ahead.
Well, you want me just to talk generally about joint ventures?
Yeah. Tell me how, when do you make the decision to do a syndication or to do a JV? What limitations exist with the JV that kind of means we can't do a JV, we got to go do something else? How
Right.
can you structure that?
All right. Well, let's appreciate that introduction. Let's assume, so we don't leave anybody behind at the starting gate, that people don't really understand what we mean by joint venture, because that term itself is frequently used to mean different things to different people. So when we talk about joint venture here, what we are talking about is a structure where the individuals involved, with the parties involved, are all actively engaged instead of a passive investor. And a passive investor is somebody who just writes you a check and sits back and waits for you to make them a profit. So that's a passive investor, and that is the term that the SEC uses. The SEC does not actually have a definition of an active investor. An active investor is an investor who's not a passive investor. That's their so it's an interesting
definition.
It's typical SEC. Not the securities laws are not only not intuitive, they're counterintuitive in a lot of respects. Even so in order for,
and I think intentionally so, Jeff. I think intentionally so.
Could be. See, so in order to be a joint venture, everybody in the joint venture, and we'll talk about how many there can typically be in a joint venture, has to be actively engaged and have enough real estate knowledge, sophistication, so that they can protect themselves and they're not relying upon the other person to make them a profit. And the simplest example that I always give is an example, and this answers two questions. First of all, it answers the question as was a joint venture, but also the follow-up question, which everybody automatically asks, is how many people can we have in a joint venture? So to illustrate, I did a joint venture. It was a residential subdivision development deal, and we had 4 joint venture partners. We had.
Okay, can I just stop you right there? Because I just, in the interest of full disclosure, one of my closing questions to you was about a residential subdivision deal that I'm trying to get into, and I want to do a joint venture. I don't want to do I want everybody to be involved in the transaction. So this is going to be very interesting for me.
So in our deal, we had the guy who found the deal and also got the loan, and we had the developer, and we had a broker, a real estate broker, who was involved in the design of the project and also in the marketing and sale of the completed product. And we had me. I came in with the money to do the deal, except for the loan, and I was also involved in every step of the way in terms of in every aspect of it. And so what we did, so everybody in this situation had a very distinct value that they were bringing to the deal. Each component that they were bringing was a material need, satisfied a material need of the deal. And people say, well, you can only have 2 people in a joint venture, and that's not true. You can have as many people in a joint venture as it's always going to be a question of fact. So you can have as many people as are actively engaged in the deal in a way that is demonstrable, and you have proof, because the only time it's ever going to come up is if the SEC ever puts it under the microscope, and then you have to have the proof. So in our situation, what we did is we had meetings. We all lived in different cities, and we had meetings every week, conference call, and we had one person be the secretary, take good notes, and really good notes, detailed about what was discussed, who said what, and we kept that record, so that if it ever came under scrutiny, we could explain what I just explained to you, and we could demonstrate what everybody did, because it was clear what the developer and the broker and the guy who got the loan and myself brought the money. All of that was automatically we could show the proof of that, but also the fact that we were actively engaged throughout the whole thing. So that is an example. Now, I'm not saying 4 is the maximum. I mean, if you got a huge deal, I mean, you could have, I don't know, you could have 10. It depends how big the deal is. Okay. So it depends how big the deal is and how much you can demonstrate. Now, what I want to emphasize, because I know a lot of people who might be listening to this, they get an idea in their head, and then somewhere down the road when they're trying to actually decide, they forget the details that we talked about, and they say, oh yeah, it can be anybody, and they forget the fact that, because I get this all the time, people who saw one of my webinars where I tell this exact story, and then they come into my office and say, okay, I want to do a joint venture, and I ask them, okay, tell me the name of the person and tell me what they're doing. I say, well, they're just going to be bringing the money to the deal. I said, okay, that's not a joint venture. If that's all they're doing, and if they're not, and has that person ever done a real estate deal before? No, they haven't. Okay, so that's the problem. So it's only 2 factors, but I get it. You know, you and I do that. You and I do what we do every day. So for us, it's in there. It's in our head. But and even though the concept, there's only 2 qualifications, only 2, but it's human nature to not remember exactly the details. So for all of you listening, great that you're listening. But if you think you're going to do a joint venture, you have to use a lawyer who's got experience in this, who understands what it is, because otherwise it's going to be a problem. By the way, I represent clients all around the country for doing joint ventures. I only do litigation in California, but I do transactions, depending on the transaction, all around the country. Anyway,
okay. Okay, so let's talk a little bit about that, because first off, in your particular case where you were involved in the transaction, you said I'm involved in all aspects of the transaction, but your specialty is law. So you were the lawyer for the group. But even if it was a deal in Michigan, you know, I guess would the SEC come in and say, well, you're not licensed in Michigan, you can't be the lawyer for this partnership, therefore the whole JV doesn't work?
Well, if that's the specific question you're asking, even if I'm not licensed to practice in Michigan, you can do certain things transactionally in other states, even if you're not licensed to practice in that state. You can't do litigation unless you get you come in under the, I just forgot the Latin term for it, whatever it is.
Pro hac
Thank you.
Yep.
Yeah, so there's not a pro hac vice for a transaction, but there are certain transactions that you can do no matter what state, even if you're not licensed to practice. And if you're ever not sure, all you got to do is call the state bar of that state and ask them the question, and they will let you know. So,
and the SEC is the one that has jurisdiction over joint venture partners?
Well, they know, because a joint venture isn't a security.
I know.
So no. The way the SEC would get involved is if the SEC is investigating for some reason, and I say for some reason, the only way the SEC is ever going to get involved as a practical matter is if the deal doesn't go the way you want it to go, and one of the partners is disgruntled, and they go talk to a lawyer, and the lawyer says, well, tell me about the deal, and the partner tells them about the deal, and the lawyer says, you know what, that doesn't sound like a joint venture. You doesn't sound like, for whatever the reason is, and I think, and if we can prove that this is really a syndication, not a joint venture, then that means that you are entitled to remedies under the securities laws. So that's the way that topic is going to actually come up. But if it's joint,
go on.
No, but if it's a true joint venture, that's the whole beauty of it. It's not a security. If you and I, let's break it down. First we built it up. Now let's break it down.
Yeah.
You and I are who we are. And you call me and say, hey, Jeff, there's a deal across the street. I'm interested. Or you want to do it? I say, sure. And we do the deal. That is the purest joint venture. It's 2 people who are going to be actively engaged, who they both have comparable experience. That's the simplest way to think about it. And just think about it in that way.
Okay, you said that one word and you glossed over it. I heard it screaming out loud. Actively involved. And
Actively
that's
engaged. Yeah.
yeah, that's the thing that people are going to be glossing over. Well, yeah, my brother just showed up and he just gave me $100,000 to get in this deal, and he and I are going to be partners in this deal. Well, is he going to be actively engaged? That's the question, and that could
Yeah. Well, and
kill
here's
the
the
deal.
and here's the other thing on that particular term. People say, and this is the next most common question. Okay, so all I got to do is have you put together the joint venture agreement and put that Charlie and Jeff are both going to be actively engaged and we're good then, right? No, it's not. That's why I say that it's not enough that you put it in the document and then in reality, the way it turns out is one person, all they did is they gave the money and you never heard from them again. So
Okay.
that's the other big, as a matter of fact, now that we're talking and I appreciate the conversation,
Yeah.
I'm going to put together a little ebook talking about the biggest mistakes people make about forming joint ventures. And it's going to be a list of these kinds of things that we're talking about.
Yeah. And I can tell you right now that what you just said, I'm going to show it to you in writing on this organizational chart. And that's where I think your eyes are going to bug out. And because this is where they're going to blow up. But before we get there, let me ask you, any case law, any federal case law, any statutes on joint ventures? I mean, if a disgruntled investor hires an attorney, where is that guy going to find the?
Yeah, there are. It's been a number of years because when I first started teaching this, and it's been a number of years since I started teaching this particular topic, I wanted to do that same research to see if I could find some good case law that addressed it. And I did, and I honestly don't even recall if I saved it on my computer. I'll look and see if I've got it, but I wanted to make sure that not only did I do the research, but I wouldn't be surprised if when you refer to the syndication lawyer that it's the same person. I know that I know her. I know
Yes.
a couple. I know several as well.
Yeah.
But I wanted to run it by another colleague to make sure that I was correct in everything that I've just been saying to you. And they said, yeah, that's correct. That's accurate.
All right, Jeff, I was not trying to play stump the professor here with you. I had a Harvard educated lawyer on my podcast a couple of weeks ago. And I said, okay, let's talk about the famous U.S. Supreme Court case Buchanan. And, he gives me this glazed over look. I said, the 1917 case that talked about racial zoning. And, I was ready for that one. No, of course, I just wanted to play stump the professor. All right. So let's talk before we get into this chart that I want to show you. And I have cleaned this chart as best I can so that we're not going to get ourselves into any trouble. I will take the hit for you though, Jeff, because that's the kind of guy I am. Let me give you an analysis. I want to give you a scenario and I want you to tell me how to do this. So I've got a partner up here in New Hampshire, and he and I are looking for land all the time. And we want to build apartment complexes. That's the next thing. The demand is so huge for our product. We can't find deals. We have to build deals. And so we are out there looking for land. Just as hard, I'm going to tell you, looking for land is as hard as looking for good apartment deals. And then we have another guy who's got deep pockets and really good guy, like him, trust him. And he says, listen, I want to get involved in whatever you guys are doing. I'll bring the money to the table. And so I think to myself, how can I structure this to avoid the SEC, to really have a great arrangement here where we're all doing things equally? And I thought to myself, okay, this guy's out of state. And I thought, okay, so my partner and I are going to find the deals, do the site work, really be involved. And this guy's going to be the money guy. And I thought to myself, but he can't be passive. He's got to be actively involved. So, and we're going to put our own money. I'm going to put like $250,000 of my own money. My partner's going to put in $250,000. So we've got money coming in. That guy might have to put in a little bit more. But what I was thinking is doing a joint venture where that guy's role is to write the checks. He handles the money. And so, we have one joint bank account. I put in my $250,000. My partner puts in $250,000. This guy puts in $1 million. And, we're off doing this stuff. I said, hey, listen, the site engineer needs a check for $15,000. And he controls the bank. He controls the accounting. He writes the check. It goes off to from the joint account. It goes off to the site engineer. And all the bills, he handles all the bills. He makes sure everyone gets paid. That's his involvement in the deal. He's active. He's, we don't write the checks. He does it all while we're out here working the deal. That could qualify as a joint venture. Do you see any issues with that? Hi, this is Charles Dobbins, the founder of the Multifamily Investing Academy and the multifamilyattorney.com. And I want to invite you to check out the best coaching, consulting, mentoring program on the internet today, the MFIA Owner Forum. Now, if you're looking to jumpstart your multifamily business, this is the program for you because it protects you every step of the way to make sure that you do these deals the right way. Believe me, I've done enough deals. I know how to do it the wrong way, and there's no need for you to duplicate my past efforts. So what the Owner Forum is a group of multifamily investors, all different levels. Some own 4,000 units, some haven't bought their first property, but we all come together to help each other get across that finish line. And within the Owner Forum, what we do is remove all of those roadblocks that every single multifamily transaction has. Check it out. Go on our webpage, click the link, try it out, risk-free, money-back guarantee, and this is not one of those $30,000 or $40,000 or $50,000 coaching programs. Those are ripoffs. The Owner Forum is a program that you deal with every single month, and we help you every single month get to your goal of being a multifamily investor. So check it out right now, and I'll see you on the other side.
Well, a couple thoughts. First of all, it just sounds, by the way you described it, as an attempt to work around it because the guy doesn't know enough about real estate. So
he does.
Here's my question. Here's my question for you.
Yep.
You're talking about a multifamily development deal, right?
Yeah.
You got a multifamily development deal. You got 3 people, and for some reason, you're not having this third guy be part of play a bigger role. Like, there's so many things that are going to be so many decisions that need to be made. You would not have him be involved in those conversations and those decisions?
Oh, no, I definitely could. That's a great point. I thought I knew Lerman was going to be the skunk at the garden party, as soon as I started giving him these things. But yes, he definitely would be involved in those types of arrangements.
Okay.
Yeah. Okay.
Because if you're saying that that's all he's doing is writing checks, and again, ultimately, it's going to be a question of fact. And if the SEC ever got involved, it would, and I'm not aware of a case where of this exact fact pattern, but that would be my concern. And why? Why take a risk that you don't have to take in that regard? So, and there's so many things that you could get them involved with besides or in addition to that. That would be my advice to you is, look at that list of, I know that list is really long for getting from where you are to getting to the finished product. And so I would encourage you to try to give him more to do than be basically he's not even a CFO, he's more like a secretary. I mean, that's, if all he's doing is writing checks, I mean, my bookkeeper writes checks.
Yeah, he's like the controller. That's really, he's
writing checks that you're telling him to write. That's what our bookkeeper does. So I would have a concern about that, and it seems like by limiting him in that respect, I think you're taking an unnecessary risk.
See, folks, that's why I have a podcast. I just got some great legal advice for free. And, that was very good points, Jeff. I appreciate it. Okay, let me show you this. This chart. I'm going to share my screen here. And I want to get your thoughts on this. Let me blow this up. Make sure this I always have to hit this twice. There we go. Okay, so check out this joint venture organizational structure. So here's the parent entity right up here. It's an LLC, manager managed LLC.
Good.
You got these managing members, 30%. These are 3 people's names behind this block. They each own 10%. Here are their responsibilities in the arrangement. They're all guarantors on the government-sponsored entity loan. One does the financial and the asset management. One handled all the acquisitions. One of them is just a guarantor signing on the dotted line. Now, these 70% of the people, these are the ones that come in as joint venture members. Now, I'll tell you something. Let me give you a little bit of background here, Jeff. This came to me from one of these people in this block, and she has zero experience in multifamily and owning any real estate. And she was given this task down here of relations and communications. So what these people did is they came up with all these different categories.
Can I interrupt you there?
Yep.
So big picture, you're saying that this person who's going to be a member in what you're calling a joint venture has no real estate experience?
I'm not calling it a joint venture. The managing members are calling it a joint venture. And yes, they're asking for this woman's $500,000 to come into the deal as a joint venture partner. And I specifically, your education was ringing in my head, Jeff. And I said, what exactly is your role in all of this? Like, what, you can't just be said you're a joint venture without being given any tasks or responsibilities.
Right.
She goes, oh no, they've already laid it out for me. And she showed me this structure. She says, I'm the relations and communications person. I'm like, wow.
Yeah.
Have you ever done that before?
Okay, so Charlie, and I love this conversation because you're really hitting on so many of the most common questions that come up when I am talking to a client. And I think everybody should listen to this once, listen to it twice, and we should actually transcribe it because there's a lot of these are important points. So think of it this way: if the securities laws were originally created back in 1933 is a reaction to what was happening after the Depression, when the country was coming back, and there was a lot of securities fraud. There were a lot of people who were trying to pull investors into their deal, and they were bringing in people who had no real estate experience, not enough information, not enough knowledge to really look out after themselves, to protect themselves. And so the SEC was born from that problem, and the main purpose and the main policy of the SEC is to help to protect those people who don't know enough to protect themselves. And so if you keep in mind on the 50,000 foot level, big picture, if you're ever wondering, is this something that the SEC would have a problem with, just ask yourself, if you tell me that if this person is coming into the deal, and yes, they are the relations and communications person, but they have no idea what a real estate deal is all about and how to protect themselves, the SEC would be concerned about that, and they would say that's exactly the kind of person that we are here to protect. Does that make sense?
Let me stop you right there, because I've got a full disclosure here. This goes back, and I want people to hear exactly what Jeff said. I want you to understand this. I'm going to put it in practice for you. My wife and I got sued by the SEC because of a partnership that we were involved in. It was a nightmare. It was terrible. It was absolute the worst time of my life. And what had happened was we had a partner in the partnership whose job it was to go out and raise money among investors. And so he would go out there and meet with the person and, get all the documents signed, and the people's money would come over. The people's money would come into our escrow account, and then we would go out and we would buy property with that account. I think we never knew what happened. We never knew, but the SEC got involved. They came in, they made our lives miserable. They blew everything up. And while we were going through the legal process, the SEC informed me that one of the investors put $35,000 of their disabled daughter's trust fund money in this multifamily deal that was a risky deal. I had no idea. I had no idea because we had somebody else out there raising the money. So you've got to understand who your partner is. You've got to make sure your partner understands what Jeff just said about what's the SEC really trying to do. They're trying to protect the people who need the protection. That we should never have. If I was there, I said, hey, listen, this is not right for you. We're not going to take your money. But my partner, he didn't care. He just took the person's money, and we got into trouble with the SEC because of it. So make sure that when you're dealing with partners, you trust them, you know they know what they're doing. And that one thing that Jeff just told you should always be on the back of your mind. I mean, that's just who I am. I never would have, the people have to understand the risks involved. But this guy, it was not a problem for him. So Jeff, I just brought your training down to, the ground level. Boots on the ground level. And it was painful. It was when I heard that. And I remember sitting in I think it was a judge's chambers when I heard that for the first time, that I had taken some disabled daughter's trust fund money. It was terrible. It was, I cringed. I thought, I'm like, I hated to admit it, but I deserve everything I get. I'm a bad person. I deserve everything I get. That's how I felt coming out of there. So
it's so, it's when you're doing deals, there are a lot of details, and it's difficult to stay on top of them all, but you do at the end of the day. If you're at the top of if you're on that level where you're at the top, you are ultimately going to have to bear the consequences. I'm really sorry.
Jeff, I know. To go through that. And you know as well as I do, one of the big arguments the SEC always use, well, you're a lawyer, so you should know better. I got that all the time too. So, hey, you know what? Yeah. That's, I took my licks. So, So, okay, so let's get back to this. We're talking about, the SEC protecting the those that need protection.
Right.
So getting back here to this, I've got this one client of mine who's never done this before, who's being invited into this joint venture with all these other big high flyers. She thinks she's, hung the moon. What's going to happen to her?
Well, let me get clear on your question.
Okay.
Is this a hypothetical, or this is the real deal you're talking about?
Yeah, this is actually, I mean, we can call it a hypothetical, but there's a great deal of truth to everything I just told you. So,
the reason I'm saying is because, are you saying that the deal's been done and we're trying to analyze if they got a problem, or are you saying this is what they're planning on doing? Is this going to be a problem? Because
well, the thing is that she was brought in, and in preparation for this call, I went through the email chain with her, and she was being pressured by them that, hey, we're closing in the next week. You got to make up your mind. You got to decide fast, to jump in here. So this is at the time, time was of the essence, but it's since passed, and I advised her against doing this. Because of, all that I've learned from you, that this is, she doesn't have the experience, and this is all made up.
If they've already done the deal, then it's a problem, because one of the other things about the securities laws is that there are no do-overs. If you came to me and said, I have this deal, I have this quote joint venture, here's my structure, did I screw up? And my answer would be yes. And the worst news is that once you violate the securities laws, you can do certain things to try to mitigate the not the risk. The risk is there to mitigate the
Remedy.
consequences.
Yeah.
And one of them is to do a rescission offering where you offer everybody in the deal, everybody, not just the one person who was in the deal who shouldn't have been, but offer everybody in the deal their money back, restitution. So
Okay, let
again,
me just tell you, in my situation, my lawyers said what it ultimately boiled down to, there was a disconnect on our website between a statement, one statement on there that no one relied on was said incorrectly. And our lawyer said, well, let us just go fix that. And we can remedy all of this by changing some documents and everybody would be fine, back in the same position. And like you said, the SEC said, no, well, you already did it. You're screwed.
Yeah.
You did it. And that's it. Yeah. It's, remedying the situation is not one of their settlement options.
Yeah. I mean, we've had to go down that road with one of our clients, and so I'm very, very familiar with it. It's difficult. Yeah. So this has problems. It has problems.
Okay. So in this particular case, how, it goes to something, just think about it from a timing standpoint. What you talked about at the beginning was, in order to get this thing as a joint venture, it's people coming together with all different aspects and training in order to put this deal together and run this deal as a profitable entity. She's being asked to come into the deal in the 11th hour. Everything has been all set up already. We'll slap her a title. She'll get a title right here, and she can put the $500,000 in, and everybody's all happy about this. But she's never, it's not her role to do the relations and communications, and she's never done it before. And this train is about to leave the station. So, at what point do we say, this isn't really a joint venture anymore? You're just looking for her money.
Yeah, at that point, that's the point.
Yeah,
it is at that point.
Yeah.
Again, it's complicated, but it's simple in that the only fact that you need to ask yourself for every person is, do they have enough real estate investing experience so that we don't have to worry that they are relying upon us to make it a good deal for them?
Yeah.
And you said it in your first statement when you said this will be her first deal. She's got no investing experience. End of story.
Yeah.
So everybody listening, I get it that a lot of this sounds complicated, but at its core, it's not that complicated. But also, again, don't assume that you understand. I'm sorry, I thought I had turned off my phone. I apologize. Twice in one podcast. I'm really apologize. I'm glad we're professionals here.
Yes, exactly. Yeah, I'll never be accused of that on this podcast. That's for sure.
Sorry about that. In any event, so again, if you're going to go into a deal, if you're going to put a deal together, get a lawyer to verify that your understanding of what's is accurate. So it's a problem.
Yeah. All right. So let me ask you this, because now we're going to get down to the final nitty gritty.
Okay.
When does someone engage you in this type of situation?
We do it. I suggest you do it as soon as you decide that you want to do a joint venture, and here's why. Because if it turns out that you think it's a joint venture, but in reality, what you're putting together is going to be a syndication, then it's very possible, and it happens all the time. I see it whenever I used to go and to these networking events and mingle with everybody and talk to people, and people are pitching people on deals, and they are doing so in violation of the securities laws. Let's assume that they're doing a Reg D 506B exemption, which is the most common exemption in the securities laws, and they're talking to people at a networking event who they've never met before, and they have no idea what their experience is, and they have no pre-existing substantive relationship, and they're pitching people on the deal, and at that point, the deal's already tainted. So the reason that you want to get clear on what you're doing in terms of whether it is a joint venture or whether it is a security, you need to, I would say, as soon as you decide, I want to buy that property, before you even sign the contract, because signing the purchase contract actually is in itself a touchstone in the process of what is a pre-existing substantive relationship, you should talk to a lawyer and say, I want to do this deal. I'm about to sign the contract, which, by the way, you should have a lawyer who is working with you to sign the contract. You shouldn't be doing that without a lawyer. And so you should have either a contract lawyer and a syndication lawyer, or we do both. We do both. We do the real estate law. We do everything involved from A to Z in that process. But you need to understand before you sign the contract if you are going to, if what you're contemplating doing is putting together a joint venture or a syndication. So that's the answer. They should be, if you're in the business of multifamily, and it doesn't even have to be multifamily, but this is, I know a multifamily is your niche. So let's just stay with that. But this is true of any, even if it's a duplex or a fourplex. I mean, you can have you could be violating securities laws if you bring in passive investors to buy any real estate.
Yeah.
But for sure, if you're going to be buying multifamily, get your team put in place before you sign the contract, and don't sign a contract before you have your lawyer who's got the experience to review it for you.
Yeah. Now, let me ask you this. So what types of documents do you put together for everyone? A JV agreement is, standard. You've got to draft that up from, it's not going to be your typical standard PPM type document. This one is not off the shelf.
Right. What we do is we start off with a memorandum of understanding for a joint venture, because we are always aware of that every one of our clients has a budget, and we're always sensitive to that, and we're always looking for ways that we can keep their legal fees as low as possible and not have them spend more than they need to up front. And so for lawyers, if somebody comes to a lawyer and says, I'm going to create this joint venture agreement, and it's a 30-page document, and then they do it, and then they bring it to the other guys and they say, well, I have a problem with this term, and this term. Well, if you knew that ahead of time, you wouldn't have had to spend all that money having a lawyer prepare a joint venture agreement that you knew the terms were on. So what we do is first a memorandum of understanding, which is going to be maybe 2-3 pages long. And in that document, we have identified what we believe are all of the essential terms that 2 or more people need to have discussed and agreed upon before they enter into a joint venture agreement. And if they can't reach agreement on a 3-page document, they're not going to be able to reach agreement on a 30-page document. So that's,
I have a memorandum of understanding from my students that they can use it whenever they say, hey, I'm going to partner with this guy. I said, go on, my product library, grab my memorandum of understanding and fill it out with this partner and see how it goes. Let's take a look. It's amazing how, when you put things down in writing, how people's memories change, how their mindset changes. They don't, hey, that's not what I said. Oh, I didn't agree to that. Like, yeah. It's amazing.
And what I like to do with my clients is, even if I don't represent everybody in the deal, which we sometimes we do, sometimes we don't. More often we don't, because it's conflict of interest. Everybody has to waive conflict of interest, and it still gets messy. So, but what I like to do is, after they complete it, I like to either get in front of them in person or like this on a Zoom call, and I like to observe the way they actually communicate in this business marriage, because I'm sure, just like you, we've been doing this for so long, and we're objective. We don't have a dog in the game. And I have seen when I can catch the nonverbal language, and I can catch the body language, whatever. And when we start talking about, okay, let's talk about cash calls, or let's talk about the buy-sell provision, whatever, talk about the tough issues. And I see that they are not communicating that effectively. They're not on the same page, or I can see whatever. I've told people who were in my office to do a joint venture, said, I think you guys should go back and offline and revisit this whole thing, because it seems to me like you guys are not on the same page.
Yeah.
And so that's, it's good that they go with people like you or people like me, and people who can be objective, who've seen it before and can point out these things. But yeah, so that's the beginning. The beginning is before when most people think it is. And so it is important for all of you listening, watching, to understand, especially multifamily where it's the bigger deals, you really do need to have that team in place well before you sign any documents. And the other thing is, if they're going to be doing an MOU, I'm going to tell them, usually I'm going to tell them, make it a non-binding MOU, because, if it's binding and it turns out between the time you sign the MOU and the time you actually get the joint venture agreement actually done, the long one, you guys have problems. Now you got a binding MOU, you got a lawsuit on your hands.
Yeah.
So I like the MOU to be non-binding, because the sole purpose is to put you through that exercise, force you into that exercise, and get agreement. Okay, once you got that, there's still a risk that between that point and getting that agreement done, there's going to be things that come up that make you change your mind. So
exactly.
Yeah.
Awesome. Hey, Jeff, thanks so much. This has been fantastic. You are, I love having you on the show. Somebody as smart and as good looking as I am. We're very rare to find.
Wow.
Yeah.
Well, I usually don't get up to that level. It's usually not. Yeah.
You were good today. You were really good today. Okay, I'll give you that one. Jeff, how
Charlie,
can
I
we
love
get a
being
hold
on
of
your
you?
show.
How can we get a hold of you?
You can call me at, I'll give a 800-553-7626. I think that's right, but it's 800-5-LERMAN, Lerman, 800-5-LERMAN. Or go to our website. We are at realestateinvestorlaw.com. That's just who you are with law at the end, realestateinvestorlaw.com. And we'll be happy to help you if Charlie's too busy. Go to Charlie first.
Oh, no. Listen, no, you do something entirely different. Listen, we complement each other very nicely. So it's good stuff. Good stuff. So, all right, Jeffrey, his name is Jeff Lerman, real estate attorney, realestateinvestorlaw.com, and good guy, smart guy. And I highly recommend Jeff Lerman. So, Jeff, thanks for being on my podcast.
Let me ask you a question before I let you go. Real quick.
Yep.
So
do I need to mute this, or do I need to stop the recording, Jeff?
No, keep it on.
Okay.
Tell me what you do. Tell me what you do that is what your primary focus is, and so everybody can understand the differences. I'm curious.
Oh, yeah.
Because I thought we did a lot of the same thing.
No, we don't. I have a whole entire coaching program.
I know that.
Yeah, that's my thing. That's 100% of my income.
Oh, I thought you were still practicing.
Oh, Jeff, why would I do that? I got the best gig in the world. Are you kidding me? Every lawyer wants to be me. I love what I do. I have such a blast doing it. And we're going to be changing it up in September. It's going to be a big change, and I'll let you know about that. But
then Charlie, what I need to do is I need to get you on one of my webinars so I can introduce you to my database.
Yeah, exactly. Let's do it. I'll have my guy call your.
Have your people call my people.
Exactly. Okay, Jeff. Thanks, man. It's great to see you again, and we'll talk soon.
You've reached the end of another episode of the best multifamily investing podcast ever. For free resources and materials, head on over to www.multifamilyinvestingacademy.com. And if you love the Multifamily Investing Academy podcast, I'd love for you to subscribe, rate us, and give us a review on iTunes. And until next time, this is Charles Dobbins, the multifamily attorney, signing off.